right, we're going to go ahead and start. I'm going to introduce you to Ben Yu, Board Chair, ACC.
Welcome, everyone. Welcome to our Business Resilience series. It is a part of a business conference, pre-conference series, and we're going to have 4 sessions, and today is the first one. Before Paul introduces our speaker, Larry, I want to introduce our CEO or the president of National ACE, Qilin, to give us a few words. This will not happen, this whole series will not happen without Qilin's leadership and National ACE support. This part of the National ACE initiative to working with different chambers, local chambers in 50 states, and to promote helping the business owners, minorities through this difficult time. Just a quick introduction, National ACE is the National Asian Chamber Commerce and Entrepreneurs. Qilin is the president and CEO of National ACE. Under her leadership and under National ACE, people probably didn't know, they have webinars, different events almost on a weekly basis, and been working with the different chambers and the minority organizations and to support many business owners and individuals and minority companies in their growing their business. So with that being said, it's an honor to have Qilin to say a few words to us. Qilin, please.
Thank you, Ben. Thank you so much for your kind introduction. National ACE is a national nonprofit organization, and our mission is to serve as a strong advocate of Asian American Pacific Islander business interests and affect a positive change on all issues that enhance and advance the goals and aspirations of AAPI business owners. For the past 6 months, we have worked closely than ever with our national network of more than 60 affiliate chambers and partners around the country to ensure that AAPI business community has the most accurate and up-to-date information about the important resources that are available to our community during this global pandemic. One of our strongest partners is the Asian Chamber of Commerce of Houston. We are so thankful to Ben Yu, Paul Gore, Barbara, and everyone, all the board of directors, all the committee members and volunteers at the Houston Chamber for providing the space for this discussion today and allowing us to have an interactive forum on very important issues, knowing your rights. And it's just so important because the Asian Chamber of Houston has done extraordinary work. I just cannot describe you. And they have a connect Houston and Texas to Washington, D.C. and also nationwide. As many of you know, we are now just beginning to see data of the impact of COVID-19 has had on the AAPI business community. That is really heartbroken whenever happens to our community. A recent report of JP Morgan Chase showed that the balance of Asian-owned business declined 22% in early April. At the end of March, revenues of AAPI business were over 60% lower than that they were in the prior year. Overall, Asian-owned business have experienced severe damage to cash balance and revenue, and they are going to require more assistance from the federal government to fully recover. So please check our website at acesmallbusiness.org, and we'll provide our technical assistance and also service without charge. And thank you again. And Larry, we're really looking forward, to listen to your webinar. And this is one of the series. So I really wish all audience can stay with us the rest of this week. Thank you.
Thank you. Thank you, Qilin. I appreciate your just introduction, and it's wonderful that we have this partnership, and even more so to hear Larry. I'm just going to introduce myself. My name is Paul Gore, Director of the Community Development for the Asian Chamber of Commerce here. We welcome you for our pre-conference, our Business Resilience series of September 23rd, 2020. As you know, the Asian Chamber has been really monitoring the COVID-19 situation since January, affecting our Asian business here in Houston. We're really happy to put this together with our national partner, National ACE. And this webinar is the first of 4 series focused on legal, communication, cybersecurity, and human resource, which is basically human resource law. Today, we're happy to have Larry Finder, Senior Counsel at Baker McKenzie, who has really extensive experience in government investigations, corporate compliance, counseling, federal grand jury, trial practice, in internal investigations, and business crimes. He has a wealth of experience consulting personal and business rights for those inside the U.S. So I hope that you find this presentation useful in understanding your legal rights here as you live in this great country of America. You know, the Asian Chamber is an organization that celebrates 30 years helping Asian business community to foster economic trades among our members. And this is a very crucial time and topic to learn about resources that allow you to help you through this uncertain and trying times. You know, but before we start and continue with this webinar, I'd like to just provide some housekeeping items. We'll have a Q&A session at the end of the presentation, which you can ask by pressing the button on the bottom, the Q&A button on the bottom on the control panel, and you'll be able to ask there, where you can type it, and you can do this in the middle of the webinar, and please submit your questions there, and we'll ask them on your behalf. Next, you know, please take note of that we're going to try to answer all the questions, but because of time, please forgive us if we can't be able to answer your question. Just want to let you know ahead of time. And lastly, the presentation will be recorded, so we'll make it available both on the National ACE Resource website as well as our website, the Chamber website, at the end of the presentation. So please stay engaged and don't worry about taking notes. We really want you to be focused and allow you to really process all the information that we're going to be covering in this short amount of time. So with that, I wanted to be able to just talk a little bit of just some of the upcoming programs. If you can look at the slides, we're going to have our Business Expo, or actually Business Conference Expo, coming up in 2 weeks. It's going to be a 4-day over 2 weeks. And as you know, this is a pre-conference session, and that really leads up to the business conference itself. We have wonderful speakers. We did announce yesterday, Secretary Ross will be one of our keynotes to open up the session and the conference itself. And even more so, there's 2 topics that we're going to be talking about, both business tools in our first week, and then trade, both locally and internationally, in week 2. It's a wonderful experience and highly interactive, where we'll have a main session, a breakout session, as well as one-to-one conversations that you can have internally with the participants, as well as scheduling your meetings, and an exhibitor hall where we're having over 50 exhibitors going to be present there. So it's a wonderful low-cost business conference that we're going to be having, and we want you to be able to register. Actually, those attending here will get a discount code afterwards that will arrive tomorrow, and you'll be able to register at a discount price just to show our appreciation and really maximize your time and value with this conference itself. And the other thing I want to be able to highlight is, in continuing our series, next week we're going to have one that's about communication, being able to understand and communicate well as you're social distancing from this. It's a wonderful event by 2 highly marketable companies who really show and guide other companies in how to really brand and market their products and services. So that's a free event happening at the same time next Wednesday. So with that, one more thing, our new app. You can download our app online and really be able to engage. Everything's at the fingertip of your hand and your mobile phone. So please download it if you haven't do that. So with that, I'm going to go ahead and pass it over to Larry, who will be able to introduce and have a wonderful thing. So Larry, I'm going to stop the screen, and if you can just press the button to start sharing screen, and the floor is yours.
All right. Well, I want to thank ACC Houston and National ACE for inviting me to speak. And I want to thank each of you on this webinar for taking 60 minutes of your time to listen to me. But a special thanks for Paul, Bin, Xiling, and Barbara for helping me get to this point today. What I'm prepared to share with you is a 30,000-foot overview of some of the things an individual or a corporation can expect in a government investigation. Each of the three topics that I will cover could be discussed for hours, but we only have about 50 minutes to address these topics at a very high level, followed by the 10 minutes of Q&A. Please understand that I am not providing attorney-client legal advice to anybody on this webinar. Every situation is unique, and my remarks are going to be made in generalities. But let me just say that there is no substitute for calling an attorney when you have legal questions, including questions involving government investigations. And those conversations that you have with a lawyer, unlike this webinar, may be covered by attorney-client privilege. So let's get started. This is supposed to be funny, but it's really very serious. Knock, knock, who's there? And then you can pick one of them on the screen. In all instances, this is not a social call. The federal departments and agencies that you see here can all do perform government investigations. You're probably familiar with some of the names on here, like FBI, Secret Service, DEA, U.S. Marshal, but ICE is part of Department of Homeland Security, and HSI is their investigative arm. BATF is alcohol, tobacco, firearms. You all know the IRS. We all know that one. Postal inspectors are a very active agency, as well as the Department of State, which does a lot of immigration and passport fraud. In addition to all these federal agencies, state, county, and local law enforcement also do investigations and have tools available to them. But basically, this PowerPoint presentation will involve agencies from the Department of Justice, Department of Homeland Security, and probably postal inspectors. So, what are the common types of government investigations, investigative techniques? And I like to think of this as a toolbox that is used by prosecutors. And the three major tools in this toolbox are agent interviews, that's federal agent interviews, but it could be on a state and local level, police interviews, grand jury subpoenas as opposed to civil subpoenas, and search warrants, which in the rest of the world are often called dawn raids. There is another tool in this toolkit, but it's not generally used. It's not as common as the three you see, and those are wiretaps or electronic surveillance. There's two types. There are criminal wiretaps, which the FBI and most of the other agencies that I showed you on the prior slide are able to do. And there's the FISA court wiretaps, which we've heard about in the news when we're listening to some political reporting. We're not going to talk about either type of wiretaps in this presentation as a matter of time. But each one of these three tools in the toolkit could be discussed for an hour or more. So let's talk about agent interviews versus grand jury subpoenas versus search warrants. We'll go into each one of them in some length. The agent interview is normally first, and if I had to talk about a danger meter, I would say the agent interviews are kind of like getting a cut on your little finger. But it will determine if there's going to be a federal investigation and whether you as an interviewee could become a person of interest. A grand jury subpoena is more serious in most cases. That's instead of a cut on your little finger, that's more like getting your hand burned by some spattering boiling water. But that means there is a criminal investigation. A grand jury subpoena means there is a criminal investigation. An agent interview may or may not result in a criminal investigation. The most serious tool in this toolkit are search and seizure warrants, or again, what are called dawn raids. And that's like dipping your arm into a vat of boiling oil. That is really serious, very, very painful. But you always remember, an agent interview can lead to a grand jury subpoena, which can lead to a search warrant. So let's talk about the common types of investigative techniques in the order which I presented it. That is starting with the agent interviews. Agent interviews can occur anywhere. And when I say agent, I'm talking about a federal agent, an FBI agent, a DEA agent, a State Department agent. They are all law enforcement officers. And these agent interviews can occur anywhere. They can occur in your home, your office, when you're on vacation out of town, if the government knows where you are. And oftentimes, in my experience, at the airport, when you're coming back from wherever it was you visited, especially if it's out of the country. if an agent calls you up and requests a meeting for an interview, that's probably the best case scenario, because there is a decent chance you may not be a person of interest in any ongoing investigation. Yet, when you hear from a federal agent, it's still a good idea and a good practice to call a lawyer before you sit down and consent to an interview. When interviews occur, there are usually two agents, one who takes notes and one who asks questions. And as I said before, it's better if it's a scheduled meeting, because that way you have a chance to talk to a lawyer first. If it's unexpected and they just show up at your work or your home or at the airport, that's probably a little more serious, because that means that the agent probably wanted to catch you by surprise. We'll talk about that in a moment. Usually, almost always, agent interviews are non-custodial. That means there's no arrest. You're not under arrest. You can say, no, I'm not talking to you. And because there's no arrest and you're not in custody, the agent does not have to give you your constitutional rights under Miranda or Miranda warnings. You're all familiar with that. I'm sure you have the right to remain silent. Anything you say may and will be used against you. You have the right to consult with a lawyer before talking. If you cannot afford a lawyer will be provided for you. But that's only if you're under arrest. And if you're not under arrest, you don't get to hear your constitutional rights. In fact, most people who, when confronted by an agent, the first thing they think they have to do is cooperate, and will consensually answer questions. Most people think I've done nothing wrong and that's why I want to cooperate. But again, you have the right to speak to a lawyer before you consent to an interview. And if you ever say the magic words, the interview should cease. And the magic words are, I want to talk to a lawyer. So again, if the interview is scheduled, you should probably ask the agent who calls you, what is this about? And then if the agent won't tell you, you should call a lawyer. If the agent does tell you that it's about a certain subject matter, then you have a little more information and you can decide whether or not you should call a lawyer. But if an agent does meet with you and hands you a grand jury subpoena, I would definitely consider calling a lawyer at that point and terminating the interview. Again, if the interview is a surprise, you certainly want to consider calling a lawyer. So let's move on to the next slide. And this is more about agent interviews. You'll see I put a lawyer on the right-hand side. That's not a real lawyer. That's an actor, William Shatner, but he played a good lawyer named Denny Crane in a TV show called Boston Legal, which you may have seen if you're old enough. I think it was on TV about 12 years ago. The point is, when you're speaking to a law enforcement officer, or LEO as I wrote, it's really a good idea to have a lawyer sitting next to you. And let me explain why. Because, well, let's be honest, people don't want to hire lawyers, mainly because it can be expensive. I understand that. I wouldn't want to hire a lawyer for myself either. And I have hired lawyers for things other than criminal matters, and it is expensive. But what a lawyer can do for you is prevent you from making damaging admissions or waiving privileges. And we'll talk about privileges in a few moments. The other thing a lawyer can help you do, if the lawyer has talked to you ahead of time, is stop you from saying things to an agent that are incomplete or not truthful. Remember, a federal agent does not have to be truthful when talking to you. They can trick you, and that's not against the law. But if you say something to a federal agent that is material, if you knowingly say something to a federal agent that is materially false or fraudulent, that is a federal felony. And it's punishable by up to 5 years in prison, unless it's a statement involving the sexual abuse of minors, or domestic or foreign terrorism, international terrorism, in which case it's punishable by up to 8 years. But I said a few moments ago that one of the things a lawyer can do for you is to help you from waiving a privilege. And let's talk about privileges for a moment. There's really two that are paramount. There's the attorney-client privilege, and that privilege, which I'm sure everyone has heard of, is in effect if there is a confidential communication between a client and an attorney. Now, the client can be an individual or the client can be a corporate representative, because corporations also have attorney-client privileges. Not just corporations, but collective entities of any kind, trade unions. It could be the Chamber of Commerce as an organization. Organizations have attorney-client privilege. And if the confidential communication, and it has to be confidential, that means between you and the lawyer, not between you, the lawyer, and your friend or your mother-in-law or father-in-law or somebody else. It has to be confidential, and it has to be for the purpose of receiving and discussing legal advice. This privilege is the privilege of the client. It's not the lawyer's privilege. The lawyer has to assert it on behalf of the client, but it's your privilege, and it can be waived by you, by the client, if you ignore any of the elements I talked about, mainly confidentiality. Now, there is no privilege if you go to see a lawyer to commit a crime or a fraud, obviously, and no one on this call, I'm sure, would do that. But you have to be very careful that you don't waive the privilege. We'll talk about waiver a little more in a few moments. Actually, let's talk about it now. What is a waiver of privilege? If you meet with your lawyer and have this confidential communication for legal advice, and then after leaving the lawyer, you go have a cup of coffee with your friend at the coffee shop and tell your friend, hey, I just met with my lawyer and this is what we discussed. At that moment, you've done two things. You've waived the privilege and you've made admissions. Now, because you've waived the privilege, the law enforcement or the government can talk to your friend and say, tell me what was said. Or they can talk to you in a grand jury and say, tell us what was said between you and your lawyer because we know you waived your privilege. The other kind of, the way to think of this is a privilege is a glass filled with water. And if you hold that glass of water, the privilege is intact. If you spill that glass of water into the sand on the beach, you can never get it back into the glass. That's waiver. The other kind of privilege is Fifth Amendment, compulsory self-incrimination. That's if you are in a legal proceeding and you say things that waive your privilege, the subject matter of what you're talking about, by voluntarily answering questions. That's very proceeding specific, but a closely related concept is an admission. If you make a Fifth Amendment waiver, you're generally making an admission. And if you make an admission, it can be used against you under the rules of evidence. So you have to be very careful when you're talking to your lawyer or talking to anybody else about any kind of legal advice that you've received, that you don't waive your privilege. So that was the agent interviews, and privilege are the first tool in the toolkit. Privilege actually will attach to all three of the tools in the toolkit. The next one is the grand jury. And the grand jury is, of all the tools in the prosecutor's toolkit, the best tool that the prosecutor has. It's like having the biggest hammer or the biggest wrench or the biggest saw. It is what makes the prosecutor the most powerful person in government investigations. And the role of the grand jury is not like a trial court. The grand jury is a constitutional body in the Fifth Amendment, actually. The Fifth Amendment says nobody can be charged with a federal felony unless a grand jury returns an indictment. The Fifth Amendment also said you have the right not to incriminate yourself. Now, when I say you, I'm talking about individuals now, because corporations don't have Fifth Amendment rights. And how do you know if a witness has a Fifth Amendment right? If you can stick a pin into the hand of the witness and blood comes out, there's a Fifth Amendment. You can't stick a pin into a corporation and get blood, because corporations, collective entities, do not have a Fifth Amendment right. But the grand jury is not an adversary hearing. You don't have two sides. You don't have your side as a witness and the government side. You have one side, and it's the government side. And as you see from the quote, the purpose of the grand jury is to decide if a crime has been committed and who committed the crime. It's a one-sided hearing, and it decides whether criminal proceedings should be brought against somebody. The other thing about a grand jury, unlike a trial, is grand jury proceedings are secret, up to a point. So whatever is said in the grand jury stays in the grand jury, kind of like that old saying, what happens in Las Vegas stays in Las Vegas. Except if there's a trial, much of what was said in the grand jury can come out into evidence. So, as I said, this is the best tool in the prosecutor's toolkit. A grand jury room, and this is just to give you an idea of what it looks like, there's a stenographer, there is the witness, there is a table where the prosecutor sits, and there's nowadays a monitor or a whiteboard to show the grand juror's evidence. Before the prosecutor sits down, there's often a magazine rack with newspapers and magazines. The grand jury consists of 21 people, unlike a 12-person trial. And those people decide whether or not to bring an indictment. And an indictment is a formal criminal charge. Grand juries charge felonies. A felony is a type of crime that's punishable normally by more than a year in prison, or up to more than a year in prison, as opposed to a misdemeanor, which is normally less than a year in prison. Grand juries don't bother with misdemeanors for the most part. They consider felony presentations. So how does the grand jury process get started? The simple answer is by subpoena. And what you're looking at are three types of subpoenas. I don't know if you can see my cursor on this, but the first one is a civil deposition subpoena. Second is a civil document production subpoena. The third is the grand jury subpoena. A grand jury subpoena may look like the other two. They all kind of look alike when you look at them quickly. And a grand jury subpoena can compel production of a person to the grand jury, an individual that is, as well as documents. But at this point, I have to tell you, the grand jury subpoena may look like the other two, but that's where the similarity ends. I like to say a grand jury subpoena, or the other two subpoenas, the civil subpoenas, may look like non-venomous king snakes with a certain color patterns on the body. It looks a lot like the venomous coral snake pattern. The grand jury subpoena is the coral snake, not the king snake. So what happens if you get the grand jury subpoena? You as an individual, or you on behalf of your company or the company you work for. While I can't give you legal advice, I can tell you what good judgment is. And good judgment is when receiving a grand jury subpoena, you get a criminal law attorney, someone who understands what a grand jury subpoena is and how it differs from the first one or the second one. Remember, they're all subpoenas, just like, let me put it this way. Surgeons and internists are both physicians, right? But you don't want an internist operating on your appendix. You want a surgeon. For the same reason, you don't necessarily want your civil lawyer to handle a grand jury subpoena and document production. The reason being, the penalties are far different. Why? Because a grand jury subpoena means, by definition, this is a criminal investigation. The other two are civil. Nobody goes to jail, to the penitentiary in a civil case, unless there's contempt of court, of course, but that's an exception. There can be contempt of court for a grand jury subpoena as well for noncompliance. But the grand jury subpoena is much more serious because noncompliance can lead to other things. And we'll talk about some of those things. For example, if a civil subpoena is not complied with, you blow it off. There might be a contempt of court, there might be a fine. Blow off a grand jury subpoena, the judge is probably going to sign an order getting whoever the witness into court, possibly fining the witness, unless it's a criminal contempt, in which case the witness can be jailed for noncompliance. But that's the least of it. Blowing off a grand jury subpoena or complying with it in part, in other words, not producing all the non-privileged information which is required to be produced, can lead to other things. It can lead to more agent interviews. It can lead to a search warrant, which we'll talk about at great length in a little bit. That's very, very serious, because someone who doesn't comply with a grand jury subpoena to the prosecutor is someone who's more than a person of interest. It's a person or a witness who has something to hide. So that's why I strongly recommend, if a grand jury subpoena is ever received by a company or by an individual, by an employee of the company, which does happen, and we'll talk about it in a little bit, that a criminal law attorney be engaged to help you or your company on how to proceed, how to respond. Remember also, the grand jury subpoena can call for things that are privileged. You may not be in the best position, or your company may not be in the best position to know what is privileged. There's a difference, for example, between attorney-client privilege documents and documents that are trade secret documents. You don't want either one of them being disclosed, especially your trade secret documents, because that may be the secret sauce to your company. You don't want it getting out there. But trade secret's not privileged. Attorney-client is privileged. And that's why a lawyer can help negotiate for you, for your company, what the grand jury can look at and what the grand jury cannot look at. And that is something that's usually done lawyer to lawyer between your or your company's attorney and the prosecutor. You don't deal with the agents who are serving these things, these processes, because the agents aren't the lawyers who are prosecuting the case. So, as I said before, if a grand jury subpoena, or if any subpoena is received by you or your company, the company should talk to its in-house lawyers or hire outside counsel, and you would do the same. But a grand jury subpoena really requires that you jump on it right away, because there may not be that much time in the grand jury subpoena for compliance. You will ordinarily have sufficient time for you to obtain the documents or the other evidence that's requested and get it to the grand jury. Many times, the grand jury subpoena calls for many hundreds, thousands, tens of thousands of documents. Clearly, that's not going to be possible to produce in a couple weeks. You have to look at it to see if there's privileged documents, like attorney-client privilege, and then through your attorney, hopefully, or the company's attorney, you make a production and what's called a privilege log of documents that you're not producing, but you acknowledge exist, but subject to privilege. So that's what the lawyer can do. The lawyer will help you if you get a grand jury subpoena and you have to go to a grand jury to make sure you don't make admissions in the grand jury, you don't waive attorney-client privilege in the grand jury, and how to ensure compliance with producing documents that are subject to the subpoena. What your lawyer can't do, though, or the company's lawyer, is go into the grand jury with you. You're on your own. The lawyer can sit in a little ante room outside the grand jury, and the witness has the opportunity upon request to go out and talk to the lawyer to see if a privilege should be asserted, whether attorney-client or Fifth Amendment, as long as you haven't waived privilege before that. Because if you waive the privilege, you've probably waived the subject matter, and then the government can pretty much go into whatever it wants. The other thing, and perhaps one of the most important things a lawyer can do for you if you get a grand jury subpoena as opposed to a civil subpoena, is talk to the prosecutor and find out whether the witness, whether an individual or a collective entity, such as a corporation or a trade union or any kind of association, is in the mind of the prosecutor a target subject or other witness. A target is a witness who the prosecutor or the grand jury calls a putative defendant. Without being too legalistic, that means someone or something that's probably going to be charged by indictment. That's very, very serious. A subject, on the other hand, is almost every other kind of witness, someone who knows something or who has done something that is within the scope of the grand jury's investigation, and the grand jury wants to know more about that witness's conduct. The third kind of witness is just like it's called other witness. Usually the record custodian from the light company, the phone company, things like that have to produce records that know nothing about what the grand jury is looking at, is just bringing in records. And nowadays, a lot of that can be done through declaration and witness and records affidavit. So let's move on. The third tool, and this one is called the search and seizure warrant, or in other countries, a dawn raid warrant. And let me stop right here for a moment. A dawn raid in other countries is handled much more cooperatively or civilly than a search warrant. The search warrant may have looked like the grand jury subpoena or the civil subpoena, but again, it's the poisonous snake. Search warrants are authorized by a judge if a police or the prosecutor present it and show probable cause, which means that there's likely reason to believe that a crime has been committed and the probability that evidence of that crime can be located in the place to be searched. If you ever see, and you've seen it on TV probably, in some of the pictures on this PowerPoint, when police or agents show up wearing blue jackets with yellow letters on the back that say federal police or FBI or DEA, whatever, they're not there for a social call. They usually come with guns showing, with their Glock 19s and their AR-15s showing, and it's all very serious. Sometimes there's a helicopter hovering above, especially if it's a corporate search warrant. There's vans or trucks to haul off boxes of documents and other evidence, and it's very, very serious. So here's what it might look like. And I can tell you, on the left here is a search warrant executed on a residence, and you can see there's a fair number of agents, but there's, there are a small number of documents being taken out. When it's on a business, that's when you're going to see the semi-trailers and the vans, because they take a lot of stuff out of the business. And this is something that can cripple a business. The photos don't really do justice to what a search warrant execution can look like. I've written many search warrants for agents. I've gone on search warrant executions, which is when the warrant is served, and it's very, very tense, and guns are being shown, and you really, when the agents come in with a search warrant, whether it's to a home or a business, they take control of the premises. They take control. You have to be prepared for that. Now, if your business is already prepared for a disaster, let's say it's hurricane disaster, flood disaster, tornado disaster, chances are you have you have a server that's off-site, because if your business gets destroyed, the building it's in gets destroyed, you still want to stay in business. And I would recommend that your most important things should also apply to a search warrant, because the government can come in and take the computers now, or your servers. Nowadays, they usually image them. They bring in external hard drives with terabytes of free space to download everything. When they download everything, they could be downloading not only proprietary information, but attorney-client and privileged information, which is why you don't want to negotiate with the lead agent on the search. You want to negotiate with the prosecutor, the lawyer, to say, hey, they're taking some stuff that's privileged, it needs to be sequestered, it needs to be segregated and put somewhere else until we can work that out. And that's really what a lawyer, the highest and best use of a lawyer, because to be perfectly honest with you, the lawyers have very little to do with a search warrant. If I'm called by a client, as I have been many times, please come to our office, we're being searched. Tell them to stop, tell them to wait. I can't do any of those things. If you're the office manager or it's your business, you can't do it either, because you basically have a court order that they're going to hand to you saying they can search the whole place. Now, if you have a safe, they'll probably say, give us the combination or we're going to take the safe and break into it. Or if you have computers and they'll say, we're going to take your computer or we're going to image it, and if you don't tell us what the password is, we're going to find it out, or we're going to give you a grand jury subpoena and you're going to have to go to the grand jury. So sometimes you may want to be somewhat cooperative, but that's the discussion you should have with a lawyer. In other words, if a search warrant is executed on your home, on you, on your business, one of the first calls you ought to make is to your lawyer, because there's very little we can do as attorneys other than talk to the prosecutor, who's the lawyer for the government, and try and work out some accommodations so you don't go out of business while the government's investigating your business. I can't stop your search. I can't direct your search. I can't tell the agents, go sit in a room here until we're ready to receive you. I can't do any of those things. As a matter of fact, the only thing I can do if I try and get in their face is get arrested for obstruction of justice. And I don't want that for me, and I know you don't want that for you. So let's talk about some of these search warrant guidelines that you'll see on this and other pages. And then I'll try and quickly go through it to leave time for questions and answers. As Paul said, this PowerPoint will be online in the PDF, so you don't have to take notes. You can actually download this at a later date. And you may want to share some of these guidelines with the people in your companies, because take my word for it, when the police come in, you're not going to remember what to do. I wouldn't remember what to do. But when I wrote these guidelines, I did it with a clear head, and some of my clients have taken them, and the receptionist has it, the office manager has it, the company executives have them, because someone has to be in charge before things get out of hand. So the first thing that needs to be done is, who is the lead agent or the law enforcement officer? Who's in charge for the government? And you find out what the person's name is. You get his or her name. What is the agency? Is it FBI? Is it DPS in Texas? Is it the California State Police? It could be, any law enforcement agency. Get their credentials, find out who they are, write it down. That's going to be very important, because you're going to have to tell people in your company. People in your company are going to have to tell outside counsel, if you hire outside counsel, which I strongly recommend at this point. And the outside lawyer is going to have to know who to talk to at the law enforcement agency. You ask for a copy of the search warrant, which you're entitled to, and usually the lead agent will give it to you. Now, a lot of times, before they give you the warrant, and this is something that you have to remember, they'll say, we have a warrant, but if you give us consent, we don't have to serve the warrant. That's usually a bad idea, to give consent. If they tell you they have a warrant, let them execute the warrant, because once you consent, you sign a form saying, come on in, look at whatever you want. Consent and a warrant does not mean that they can take interviews. So that's a thing we'll talk about, another thing we'll talk about in a moment. But it is a good idea to let the lead agent know that you have no reason not to cooperate, and if they want a conference room so they can talk to themselves or put evidence in, you'll try and provide a room. In the meantime, you call your lawyer or the company's lawyer, right, who will hopefully call outside counsel who knows a little more about these things, and start a conversation with the prosecutor, even as the search warrant is going on. The next thing is that if there is proprietary information, like trade secret information and or privileged information, that needs to be told to the prosecutor if the prosecutor can be reached, but certainly the lead agent. So you say, this is what we have, which we believe is privileged. This is what we have that we know is proprietary. Please put those in separate boxes off to the side. We'll have our lawyer talk to the prosecutor and try and work that out, but please do not put that where everyone can see it. We're out of business if it gets out, if it's proprietary or trade secret, and if it's attorney-client, no one's allowed to look at it anyway. And normally the agents will agree to that, and almost always, certainly, the prosecutor will. Another thing is there's going to be non-essential personnel. Ask the government, can they go home? And if they can, you let them go home, but you tell them, do not start emailing about this, don't talk about this. Basically, keep your mouths closed until we've talked to our lawyer, until we can find out what's going on, and then we'll have a meeting at the office. But in the meantime, please don't say anything. Most important, you tell your people, do not throw away or delete anything while the agents are there, and even after the agents leave. That could be obstruction of justice. Even in a civil case, once a lawsuit's filed, you don't delete or throw away what could be important evidence, like emails, because that's called spoliation of evidence, and that can be used against you in a civil case as well. The difference is, it may be obstruction of the civil case, but no one goes to prison for it. In a search warrant situation, it could be obstruction of justice, and someone could go to prison, or at least be charged with indictment. Sometimes the agents will say, we want to talk to some of your people, or we want to talk to employees. Now, again, remember what we talked about in agent interviews, the first tool in the prosecutor's toolkit. Any employee, any witness has the right to talk to a lawyer before agreeing to talk to a law enforcement person. That can be told to your employees. But you cannot say, under no circumstances talk to the feds, under no circumstances talk to the police. You do that, then that could be obstruction of justice. You say something along the lines, anyone who wants to consult with a lawyer before agreeing to talk to the law enforcement has the right to do so. You can call your own lawyer, and the company, if you don't have a lawyer, the company will make arrangements for you to have a lawyer. Normally, the company will pay for 1 or 2 lawyers to talk to employees to give them their legal rights. That's a really good idea for you to do, unlike just telling the employees don't talk. Don't talk can get you in big trouble. Do not follow the agents around with a video camera or your smartphone. That will get you in trouble. They can tell you to go to sit down. I've even, I haven't seen it, but I've heard of one case where they handcuff someone to the chair. So you don't want to get in the agent's way. Let them do their job. You don't want them there. You can't wait till they leave, but you don't want to get in their way. So try and take notes of what they're doing. If you see them talking to certain people, employees, make a note to talk to that employee later. What did you discuss with the law enforcement officer? If you overhear something that the agents are saying to themselves, make a note of that so you can share that with the lawyer that's going to represent you and or your company. Remember, they can take your computers, but probably they'll image them. It's very important for you to try and find out what they've imaged, which standing alone PCs they've looked at or imaged. That you're going to want to do, and your lawyer will probably want the company to hire its own forensic experts to see exactly what the government took, because you are not going to get access to your evidence for probably for some time. Maybe you won't get it back until your lawyer files a motion with the court to at least get a copy of what the government took. You don't want to be out of business. So you may need to get a forensic assessment of what was taken. But again, if you have something off site, that may be the answer to what was taken from you, so you can still do your business on a daily basis. Before the agents leave, they're supposed to give you something called an inventory of items that were taken. It's called the search warrant inventory. They have to fill it out. The agents have to fill it out and leave it behind. Generally, it's very general. It may say file cabinets in room 12, or without going into much more detail. So you'll have an inventory, but it may be almost useless. Do not do the following during the search: argue or physically interfere with the agents. That will likely get you in a lot of trouble, you or others at your company. We already talked about don't use a video device to record. Don't challenge the police or the agents about their scope of authority, or because if they're there with a warrant, they have authority. If for you to say, I've read the warrant, you don't have the right to go into the building behind, that's probably not going to work either. So remember, the police control the premises while they're executing the warrant, not you. Your lawyer can't stop it at that point. Make sure that your employees who are still there are not making unnecessary phone calls, or the employees who went home are not making unnecessary phone calls or discussing what just happened with anyone else, because rumors will get around, and that's not good. The other thing to be aware of is that after there's a search warrant, it is highly likely that a grand jury subpoena will issue to the company and to certain people at the company, probably officers or managers, because what the government doesn't get, or what they miss during a search warrant, they're going to hope to get via a grand jury subpoena. So one of the things you should be aware of is to make sure that there is a document retention at that point. Do not throw stuff away, especially if a grand jury subpoena has issued. Do not delete from a computer. Your lawyer will advise you how to work with your IT people to make sure that things are not deleted, emails and other electronic evidence. And certainly, you may have to actually use a storage unit or several rooms in a storage unit to get to put trash in, to store trash for a while, because you're not going to know what you should or shouldn't throw out for a little while. That's something your lawyer can help you with. Talk to the employees, as I said, who were present for the search, who talked to law enforcement, see what that was all about. And tell employees they may get a grand jury subpoena. And as I mentioned before, when the agent drops off a grand jury subpoena, that's a good time for the agent to try and chat it up with your employee and they'll say, hey, you're not in trouble. We're looking at the company. Answer a few questions for us. Again, the employee, the witness, has a right to talk to counsel before deciding whether or not to talk to the agent. And if it's not in the grand jury, then the employee has the right to be questioned with his or her attorney present. Very, very important. The IT people can take a snapshot of your server periodically. So if there is a warrant, you'll have an idea of what's taken, and definitely take a snapshot of the desktops and the servers after a search warrant. So let's talk in the last few moments that I have the difference between a grand jury subpoena and a search warrant. The grand jury subpoena is issued by a prosecutor, can be based on rumors, suspicious. It can be served anywhere in the United States, unlike a civil subpoena, which has a geographic limitation. The grand jury subpoena can demand production of evidence on a date, time certain, subject to negotiation. You can ask the government, can we produce prioritize what we're going to produce? Can we have more time? That's something your lawyer can do for you. Privileged documents can be separated and adjudicated by your lawyer in front of a federal judge or a state judge if necessary. Non-compliance with a grand jury subpoena can lead to an issuance of a search warrant. The search warrant, on the other hand, has to be issued by a judge, not a prosecutor. It must be executed within the judicial district. For example, I'm speaking to you from the Southern District of Texas, which goes from College Station down to the border in Mexico. The seizure of evidence that's covered by the warrant will be subject to immediate seizure. It's not like a grand jury subpoena. They don't come in when you get a grand jury subpoena and take everything. That's what a search warrant is. That's the difference. Privileged documents might be seized by the search warrant, but hopefully can be negotiated to be separated and sequestered until a later date. And maybe if the government's going to look at it, then they have what's called a clean team of agents or prosecutors that are not involved in the investigation that can say, yes, this is proprietary, yes, this is privileged. And following the execution of a search warrant, a cleanup grand jury subpoena may issue. So that's pretty much what I have for you right now. I've used up most of my allotted time, or all of my allotted time. So Paul, if you could tell me if there's any questions, I'll try and answer them.
Yeah, thank you so much for coming aboard. A lot of good information. There are questions here, so I'm going to just go through some of the questions. One of the questions says, your statement about federal agents not being required by law to be truthful, does this extend to other federal agencies such as FDA?
If it's a federal investigation that has any kind of, well, let me back up. Some agents have civil and criminal responsibility. The FDA does have its own investigators. Normally, they are not, most of them are not criminal investigators. They are more likely to be truthful with you. But criminal investigators, and I'm thinking of the Bluebell case that was recently in the news. It was an FDA investigation, and the FDA normally works with other agencies like the FBI, or although they do have their own investigators. But again, there is no law that says they have to be completely truthful. You have to be, we have to be completely truthful. Investigators, unless it's really egregious, tend to, not all the time, but on occasion, will stretch the truth. And that's something that is troublesome, but you have to be cautious.
Okay. Next question. I'm an interpreter frequently assisting attorneys in conducting interviews. Is the conversation between the attorney and their client through an interpreter is protected by privilege? In other words, can anyone be subpoena the interpreter's notes during a criminal investigation?
If an interpreter is hired by an attorney for the witness, then the notes ought to be covered by the attorney-client privilege. If you are not an attorney and you hire your own interpreter to translate what the FBI agent's telling you, for example, that is not privileged. There's no attorney involved. Even if the agent, some FBI agents are lawyers, but that doesn't make it privileged.
Okay, thank you. Next question. I'm just going to go down the question. Just to confirm, it's illegal to provide untruthful information to a prosecutor, or to an investigator, but it's legal to the investigator to prove untruthful information to the interview. So that's just confirming that's, yeah.
Yeah, so sometimes agents will, or police will trick someone saying they have evidence they really don't have yet, and that's not a crime. It may be brought up in court. Certainly the agent, if it's in court, the agent can't lie in court. If they're on the stand, they're sworn to tell the truth like any other witness. But I think I answered that question 2 or 3 questions ago.
Yeah, thank you. For an agent interview, do you need a criminal lawyer or a civil lawyer?
Well, it depends. If the agent is involved in a civil, let's say an FDA or a medical device thing, and they're there for what's ostensibly a civil reason, then it's probably okay to have your civil lawyer. But remember, anything that is civil can turn criminal, almost anything. So if the FDA is there, or HHS is sending someone out from the IG's office, and they're looking at a doctor, for example, that is prescribing anti-cancer or cancer medication, and let's say it came from India, and that could be a crime to use that in this country. Would you want your civil lawyer there, or would you want a criminal practitioner there? Oftentimes, people with my background get hired by civil lawyers who are saying, this looks like it might be going criminal. I don't want to compromise my client. Will you work with me on this? And in most of my representations, I work, or at least half of them might say, I work with civil lawyers who represent the same clients who've gotten me involved in the representation.
Okay. No, thank you. I'm just just a couple more questions, and I know we're almost close to time, but I do want to answer these questions. Am I obligated to surrender my cell phone, personal and business, during the search warrant? And the second following that, am I obligated to give my passwords to the search officer or emails for my emails and cell phone?